We are now recording again. Now, if you think this is crazy, and if you think there's no way that they could imprison you because, you know what it says here? We got to be invaded, an invasion of the territory of the United States or its possessions, declaration of war by Congress, or insurrection within the United States in aid of a foreign enemy. How many of you sheeple have ever read the Omnibus Counterterrorism Bill submitted to Congress by William Jefferson Clinton and eventually passed and enacted into law by the Congress of the United States of America, which gives the President the sole means of determining who is and is not an enemy of the United States, is a terrorist, is operating in conjunction with any foreign power, and it gives him, ladies and gentlemen, the power to name any group, any organization, or any person or persons, to have them arrested without benefit of habeas corpus, without trial, and to be deported out of the United States if that's what they want to do with you, or to just lock you up in some dungeon somewhere where you will be forgotten forever. You didn't know that? Well, I suggest that you get Oklahoma City Day One, because the entire text of the counterterrorism bill is printed in the appendix of that book. 640 pages of the documented and sourced truth of what really happened in Oklahoma City on April the 19th, 1995.
Oh, well, I'm not going to read it because the law is too hard to understand.
Only if you're a complete brainless idiot who never studied English in your life and can't use a dictionary. And my little 8-year-old daughter can do all of those things. So, how about that? How about that, folks? The law goes on to outline a course of action for the arrested individual that, in general, is at odds with normal judicial procedure. Oh, really? Is that a surprise? He first would be given a hearing without right of bail before a preliminary hearing officer whose decision could then be appealed to a detention review board. At no time, though, is the Attorney General required to furnish information, the revelation of which would disclose the identity or evidence of government agents or officers which he believes it would be dangerous to national safety and security to divulge. Shades of Adolf Hitler, my goodness. In other words, the government can decline to present any evidence whatsoever, in effect transforming the traditional presumption of innocence into a presumption of guilt. The burden of disproof is on the prisoner. These same ground rules apply to any later review of the case by the United States Court of Appeals. The McCarran Act was passed overwhelmingly by frightened liberals and conservatives alike in both the House and Senate, vetoed by President Truman, then passed again over his veto. Though it was approved with the rest of the act, the Title II amendment was blasted by Senator Pat McCarran himself as a concentration camp measure pure and simple. Senator Carl Munt tagged it a program for establishing concentration camps into which people might be put without benefit of trial, but merely by executive fiat, simply by an assumptive mind that an individual might be thinking about engaging in espionage or sabotage, might be thinking, an assumption that an individual might be thinking about engaging in espionage and sabotage. You see, ladies and gentlemen, this is what I've been telling you for years. Quit this Republican, Democrat, all of this other baloney joke. You're either for freedom or you're not. If you're for big brother government and more laws and more welfare and more this and more regulation and more licenses, you are not an American. if you are for freedom, if you are for the disclosure of all of these secret things like this, if you are for the protection of the rights of the individual, if you are for the Constitution for the United States of America, welcome aboard. If you're not, you're an enemy of the Republic. I don't care what you call yourself. I don't care who you are, and I don't care how mad this makes you. I just simply don't care. It just blows everybody's mind on the internet when they attack me somewhere, and I send them a message back saying, I just don't care what you think. Period. I can read. I understand what freedom is. I understand what despotism is. I understand what tyranny is. And if you promote any of those things, I don't care what you think. I am your enemy. Simple as that. Simple as that. What you think doesn't even register a little bit on a scale of respect here. I've been all over the world as a boy and as a man. I fought a war. I've seen what despotism is. I've seen what tyranny is. I've seen what freedom is, what it can be, and how it's being taken away. And I see how most of the American people are fooled into thinking that tyranny is freedom. It's not. It's not. Said the old North Dakota dissenter, Senator William Langer, and I quote, "So it is now proposed to have concentration camps in America. We can be absolutely certain that the concentration camps are for only one purpose, namely to put in them the kind of people those in authority do not like," end quote. Actually, there was a very grisly precedent for this type of mass imprisonment. During World War II, the government arrested, confiscated the property of, and granted no hearings to or redress for the 109,650 Japanese Americans who were held in 10 relocation centers. The United States Supreme Court, moreover, unanimously upheld this action in 1943, and its decision was cited by Congress in 1950 to justify America's first peacetime concentration camp measure. It is now and was then and always will be unconstitutional. The federal government cannot do anything more than what is granted to it by the Constitution for the United States of America. And that does not include concentration camps. In fact, in a state of emergency, the only power given to the federal government by the Constitution of the United States of America is the temporary suspension of habeas corpus for the duration of the emergency only. Period. They don't have the power to suspend the Constitution. They don't have the power to take away any rights of the people. The only power they have is to suspend temporarily, during the course of the emergency, only the power or the writ of habeas corpus. Title II, Section 104, small c of the McCarran Act provides that persons detained shall be confined in such places of detention as may be prescribed by the Attorney General. In 1952, accordingly, the Justice Department designated 6 sites for the detention camp program. Listen very carefully. Go check it out. Camps were set up on a standby basis at Allenwood, Pennsylvania, Avon Park, Florida, El Reno, Oklahoma, Florence and Wickenburg, Arizona, and Tule Lake, California. So the United States does indeed. So the United States does indeed. So the United States does indeed have a concentration camp law as well as camp facilities to match. Yet both were byproducts of Joe McCarthy-era frenzy, and neither law nor camps have ever been put to use for emergency detention purposes, but they can be. The law has since been expanded, ladies and gentlemen, and money has been allotted by the Congress to build them all over the place. And they are being built and have been built, and some will continue to be built. Don't believe me? Look it up. Look it up, ladies and gentlemen. What do you think about that? Did that get your blood boiling? Well, it should. I mean, you should be hot about this.